Picking up midway into the fatf 40 recommendations, and not really sure where I left off on page 28, but we'll start up at countries should. We're in recommendation 37. Still talking about best practices for like regulatory and investigative officers. Countries should, when making mutual legal assistance requests, make best efforts to provide complete and factual legal information that will allow for timely and efficient execution of requests, including any need for urgency, and should send requests using expeditious means. Countries should, before sending requests, make best efforts to ascertain the legal requirements and formalities to obtain assistance. The authorities responsible for mutual legal assistance, for example, the central authority, will be provided with adequate financial, human, and technical resources. Countries should have in place processes to ensure that the staff of such authorities maintain high professional standards, including standards concerning confidentiality, that should be of high integrity and be appropriately scaled. Mutual legal assistance, freezing, and confiscation. Countries should ensure that they have the authority to take expeditious action in response to requests by foreign countries to identify, freeze, seize, and confiscate property laundered, proceeds from money laundering, predicate offenses, and terrorist financing instrumentalities used in or intended for use in the commission of these offenses or property of corresponding value. This authority should include being able to respond to requests made on the basis of non-conviction-based confiscation proceedings and related provisional measures, unless this is inconsistent with fundamental principles of the domestic law. Countries should also have effective mechanisms for managing such property, instrumentalities, or property of corresponding value, and arrangements for coordinating seizure and confiscation proceedings, which should include the sharing of confiscated assets. Extradition. Recommendation 39. Countries should constructively and effectively execute extradition requests in relation to money laundering and terrorist financing without undue delay. Countries should also take all possible measures to ensure they do not provide safe havens for individuals charged with the financing of terrorism, terrorist acts, or terrorist organizations. In particular, countries should ensure money laundering and terrorist financing are extraditable offenses. B. Ensure they have clear and efficient processes for the timely execution of extradition requests. A case management system should be maintained. And C. Not place unreasonable, unduly restrictive conditions on the execution of requests. And D. Ensure they have an adequate legal framework for extradition. Each country should either extradite its own nationals or, where a country does not do so, solely on the grounds of nationality, that country should, at the request of the country seeking extradition, submit the case without undue delay to its competent authorities for the purpose of prosecution of the offenses set forth in the request. Those authorities should take their decision and conduct their proceedings in the same manner as in the case of the other offense of a serious nature under the domestic law of that country. The countries concerned should cooperate with each other, in particular on procedural and evidentiary aspects, to ensure the efficiency of such prosecution. Where dual criminality is required for extradition, that requirement should be deemed to be satisfied regardless of whether both countries place the offense within the same category of offense, or denominate the offense by the same criminality, provided that both countries criminalize the conduct underlying the offense. Consistent with the fundamental principles of domestic law, countries should have simplified extradition mechanisms such as allowing direct transmission of requests for provisional arrest between appropriate authorities, extraditing persons based only on warrants of assets or judgments, or introducing a simplified extradition of consenting persons who waive formal extradition procedures. The authorities responsible for extradition should be provided with adequate financial payments and technical resources. Countries should have in place processes to ensure that the staff of such authorities maintain high professional standards, including standards concerning confidentiality, and should be of high integrity and be appropriately skilled. Other forms of international cooperation. Countries should ensure that their competent authorities can rapidly, constructively, and effectively provide the widest range of international cooperation in relation to money laundering, associated predicate offenses, and terrorist financing. Countries should also do so both spontaneously and upon request, and there should be a lawful basis for providing cooperation. Countries should authorize their competent authorities to use the most efficient means to cooperate. Should a competent authority need bilateral or multilateral agreements or arrangements such as a memorandum of understanding, these should be negotiated and signed in a timely way with the widest range of foreign counterparts. Competent authorities should use clear channels or mechanisms for effective transmission and execution of requests for information and other types of assistance. Competent authorities should have clear and efficient processes for the prioritization and timely connection of requests and for safeguarding the information. Interpretive notes to the factory recommendation. So I don't have to look this up separately. It's within the factory recommendation. Interpretive note to recommendation 1. Assessing risk and applying a risk-based approach. Risk-based approach is an effective way to combat money laundering and terrorist finance. In determining how the RBA should be implemented in a sector, countries should consider the capacity and anti-money laundering, countering the financing of terrorism experience of the relevant sector. Countries should understand that the discretion afforded and responsibility imposed on financial institutions and designated non-financial bodies and professions, DNFBPs, by the RBA is more important in sectors with greater AML, CFT capacity, and experience. This should not exempt financial institutions from DNFBPs from the requirement to apply enhanced procedures when they identify high-risk scenarios. By adopting a risk-based approach, competent authorities, financial institutions, and DNFBPs should be able to ensure that measures to prevent or mitigate money laundering and terrorist financing are commensurate with the risks identified and would enable them to make decisions on how to allocate their own resources in the most effective way. 2. In implementing the RBA, financial institutions and DNFBPs should have in place processes to identify, assess, monitor, manage, and mitigate money laundering and terrorist financing risks. The general principle of an RBA is that where there are higher risks, countries should require financial institutions and DNFBPs to take enhanced measures to manage and mitigate those risks, and that, correspondingly, where the risks are lower, simplified measures may be permitted. Simplified measures should not be permitted whenever there is a suspicion of money laundering and terrorist financing. Specific recommendations set out more precisely how this general principle applies to particular requirements. Countries may also, in strictly limited circumstances and where there is a proven low risk of money laundering and terrorist financing, decide not to apply certain recommendations to a particular type of financial institution or activity, or DNFBP, see below. Equally, if countries determine through their risk assessments that there are types of institutions, activities, businesses, or professionals that are at risk of abuse for money laundering and terrorist financing, and which do not fall under the definition of financial institution or DNFBP, they should consider applying AML, CFT requirements to such sectors. Obligations to pay Obligations and decisions for countries. Interpretive note 3. Assessing risk. Countries should take appropriate steps to identify and assess the money laundering and terrorist financing risks for a country on an ongoing basis, and in order to inform potential changes to the country's AML CFT regime, including changes to laws, regulations, and other measures. 2. Assist in the allocation and prioritization of AML CFT resources by competent authorities. And 3. Make information available for AML CFT risk assessments conducted by financial institutions, media, and FPPs. Countries should keep the assessments up to date and should have mechanisms to provide appropriate information on the results to all relevant competent authorities and self-regulatory bodies. Financial institutions and FPPs. Higher risk. Paragraph 4. Where countries identify higher risks, they should ensure that their AML CFT regime addresses these higher risks and without prejudice to any other measures taken by countries to mitigate these higher risks, either prescribe that financial institutions and FPPs take enhanced measures to manage and mitigate the risk, or ensure that this information is incorporated into risk assessments carried out by financial institutions and FPPs. In order to manage and mitigate risk appropriately, period. Where the fatf recommendations identify higher risk activities for which enhanced or specific measures are required, all such measures must be applied, to the extent of such measures may vary according to the specific level of risk. Lower risk. Recommendation 5. Lower risk. Countries may decide to allow simplified measures for some of the FATF recommendations, requiring financial institutions or FPPs to take certain actions, provided that a lower risk has been identified. And this is consistent with the country's assessment of its money laundering and terrorist financing risks, as referred to in paragraph 3. Independent of any decision to specify certain low-risk categories in line with the previous paragraph, countries may also allow financial institutions and FPPs to apply simplified customer due diligence measures, provided the requirements set out in Section D below, obligations and decisions for financial institutions and FPPs, and in paragraph 7 below are met. Paragraph 6. Exemptions. Countries may decide not to apply some of the FATF recommendations, requiring financial institutions or FPPs to take certain actions, provided A. There is a proven risk of money laundering and terrorist financing. This occurs in strictly limited and justified circumstances, and it relates to a particular type of financial institution activity, or FPP, or B, a financial activity other than the transferring of money or value is carried out by a natural or legal person, or an occasional or very limited basis, having regard to quantitative and absolute criteria, such that there is a low risk of money laundering and terrorist. While the information gathered may vary according to the level of risk, the requirements of Recommendation 11 to routine information should apply to whatever information is gathered. Supervision and monitoring of risk. Supervisors, or SRBs, or relevant DNFBP sectors should ensure that financial institutions and DNFBPs are effectively implementing the obligations set out below. When carrying out this function, supervisors, or SRBs, should, as and when required in accordance with the interpretive notes of recommendations 26 and 28, review the money laundering and terrorist financing risk profiles and risk assessments prepared by financial institutions and DNFBPs, and take the result of this review into consideration. B. Obligations and decisions for financial institutions and DNFBPs. I'm going to read, since I'm getting close to that 15 minutes